Well, I can almost say a happy new year to all of you. And maybe you are watching this in the new year. So happy new year if it is the new year already. And either way, we are going to be talking about the Karen Read case once again. And the reason for that is that a couple of days ago, I put out a video in which I shared an idea that I had if I was representing Karen Read, how I would argue that there was a conspiracy here. Now we spoke about whether there was a conspiracy, whether there wasn't a conspiracy, but this is, I think, a way to present it in a way that's more palatable to a jury. Why? It's very difficult to convince people of conspiracies, right? People don't want to be labeled as conspiracy theorists. It's very difficult to prove. So how do you prove to a jury that there's a conspiracy? So I think that one of the ways to do that effectively is by highlighting the coincidences that occurred that the jury would have to believe. Meaning, you want to show the jury, look, I understand it's a leap to start believing in conspiracies, but if you show them the other side of the coin, and the other side of the coin also sounds a little ridiculous, how you can assume that all these coincidences happen to have happened in the same time. That's also a little bit difficult to believe. So you're kind of showing the jury, look, I understand it's difficult to believe a conspiracy. It's also difficult to believe that all of these coincidences happen at the same time. So I just showed this idea. We ran through all the coincidences, and I kind of borrowed that idea from Michelle Trocona's trial, which was actually used by the prosecutor to get a conviction against Michelle Trocona to show that she was part of this conspiracy to murder Jennifer Dulas. Anyway, that's what I showed. And again, this is not to say that Alan Jackson needs any of my help. He doesn't need any of my help. Okay. He's quite qualified. That entire defense team is quite qualified. They don't need any of my help. All right. But this is just an idea, just a exercise that when I'm watching these trials, I'm thinking, how would I argue my closing arguments? And as you know, if you've been watching, I like to use PowerPoints. I always like to walk the jury through PowerPoints. I think it's helpful for them. I think it's effective. It kind of organizes everything. And that's just how I do it. So I kind of walked you through. If you haven't seen that yet, go look at that other video. Go check out that other video in which I went through all the coincidences that you have to believe in order to believe that this was not a conspiracy. Now, again, like we said, if you try to take each one individually apart and try to explain why it's not a coincidence, yeah, you can try to do that. But what you're trying to show to the jury is that, look, all of these coincidences together, it's just hard to believe as well. So it's hard as it is to believe that there's a conspiracy. It's also hard to believe that all these coincidences happen. Now, today we're going to be talking about a different idea that also probably I would incorporate into my closing argument if I was arguing on behalf of Karen Read. So again, like I always like to do, I have a PowerPoint I'm going to share with you in one moment. But the general theme, which I always love to argue to the jury, and I don't remember any trial that I didn't argue this to the jury, is the jury instruction, which talks about common sense. I've always argued to the jury that my position is much more of a common sense position. And it kind of is a little bit relieving because you're relieving the jury of thinking that they have to go through all this evidence and it's convoluted and it's difficult. You want to make their job easy. So as a lawyer, you want to make the jury's job easy. Don't make it. I always tell the jury, no matter how complicated the case is, I always tell the jury from day one, this is a simple case. It's a simple case. If you just follow the evidence, you're going to see that I'm right. That's all. It's a very simple case. And I try to explain that to the jury. Okay. Anyway, so using common sense is a great way also, I think, to let the jury say, look, you just have to use your common sense. That's all. You don't have to get so wrapped up in the evidence and trying to explain everything. You're allowed to use the common sense. Not only are you allowed to use common sense, but it's actually a jury instruction. Okay. So here we go. I'm going to pull up my PowerPoint. I'll show you kind of what I would be doing if I was the defense attorney. So I'm going to sound like a defense attorney. So by the way, if you want me to do this on behalf of the prosecutor, you want me to step into Adam Lally's shoes, I can definitely do that also. So, or this next trial is going to be Hank Brennan. So if you'd like me to put out also kind of some slides, how it would sound from the prosecutor, if I was the prosecutor, I'm definitely happy to do that. Let me know in the comments. But I think a lot of people have been liking the way that the last video came out. So I'm going to show also from the defense attorney's perspective. Again, this is not to say I can't do it from the prosecutor's point of view also, but just for this point of this video, we're going to step into the defense attorney's shoes. Okay, so here we go. I'm going to pull up the PowerPoint and we're going to go through it. So, ladies and gentlemen, the Judge Canoni, just instructed you that, or she's going to instruct you, something about called the common sense jury instruction. And this is exactly what she's going to tell you. As jurors, you may bring to bear all your knowledge and experience. You don't check your common sense at the door to the jury room. Just the reverse. I instruct you to use your common sense. Give the evidence a reasonable and fair construction in the light of your common knowledge and experience. So, ladies and gentlemen, not only can you use your common sense, but Judge Canoni is actually going to instruct you that you must use your common sense. And I'm very happy that she is doing that, because if you use your common sense in this case, there's only one verdict that's going to make any sort of sense, and that is going to be to acquit Karen Read. Okay, so let's move on. Here we go. Ladies and gentlemen, this is the picture that you've seen so many times, and you're going to be probably seeing it again in the jury room. Now, to make life a little bit easier, because you're going to start thinking about all the evidence, let's wind it back a little bit. Let's just talk about this in common sense. Let's just talk about common sense. Imagine you don't know anything about this case, and someone would just show you this picture. Okay, so someone just show you that picture without knowing anything about the case. What would your common sense and life experiences tell you those injuries were from? And even if they wouldn't give you options, I submit to you that you would most likely say, and maybe many of your friends and family would also say, that that's a dog bite or it's an animal attack. Now, let's take it the next step. The next step would be, let me give you an option. Either that came from an animal attack or from being hit by a car. If you have those two options without knowing anything about the case, just those two options, what would common sense and your life experience tell you about those injuries? And again, I submit to you that you would absolutely come down on the side that that is most likely an animal attack. Now, listen to this. I don't even have to prove to you that this was an animal attack. You can even most likely think that it's a car attack, that this was hit by a car. But if there's a reasonable doubt, even if there's just a reasonable doubt that that actually came from an animal, well, then you're going to have to acquit Karen Read. So I think that we've actually proven, just using your common sense, that that's from an animal, but that's not even my job. I just have to show you that that's a reasonable conclusion, which definitely I submit to you it is. All right, now let's move on. Now that we've understand kind of the common sense, now we have to examine some of the evidence. That's what you're supposed to do. You're not just supposed to look at just complete common sense. You got to use some of the evidence as well. So let's talk about the different options in this case. You can either come down on the side that this wasn't an animal attack, or that, like the Commonwealth theory, that this was a car accident. All right, well, let's think about the animal side first, and then we'll go to the car side. We want to be fair and even, and we'll talk about both theories. So if it's an animal, well, number one, that's common sense. I would submit to you definitely that it's common sense just by looking at the picture. Number two, we had Dr. Russell. Dr. Russell, who was an ER physician for many, many, many years, also was in forensics, and she did multiple autopsies. She treated over 1,000 animal attacks, and her opinion was that all of those wounds are consistent with being a dog attack, and she walked you through that. Then we have Dr. Sheridan, who did 13,000 autopsies. He also opined that that was more consistent with an animal attack. Then we had Dr. Wolf. You remember Dr. Wolf, the ARCA expert, who was completely independent. We didn't hire him. He was available to the prosecution as well. They could have called him. We didn't hire him. We didn't pay him a cent. This was his independent, objective opinion that it was not possible that this was done by a car. Then we had Dr. Rentschler. And remember, Dr. Wolf also has a PhD in electrical and computer engineering. He's the director of accident reconstruction. And he specializes in the field of accident reconstruction, human factors, and lighting. Then we had Dr. Rentschler, who has a PhD in bioengineering, and he's the director of the biomechanics and human factors at ARCA. He also testified to the same thing. So all of this evidence is consistent with your common sense that it was from an animal. Now, let's see the other side. Got to be fair. All right, car. Well, number one is we have to overcome the hurdle that it's not common sense. Again, I submit to you that just without knowing anything about this case and just given those two options, you would side more likely on the side of that it was an animal attack. Now, that's not to say, like I said, it's not to say that if there's solid evidence that this is actually a car accident, then you can ignore your common sense. So, but we do have to acknowledge that it's not common sense. All right. So who testified that these injuries are consistent with a car strike? Well, the only person that I can think of from the evidence that we can arguably say that his opinion was that it was from a car is Trooper Paul. Everybody else was not sure, couldn't be 100%. No one was really positive about it. Trooper Paul was maybe what you can argue is more that this was actually a car strike, and therefore these injuries were the result of a car strike. Well, Let's think about who Trooper Paul is. Is he any expert? Is he an MD? Well, he never treated anyone with any animal wounds like Dr. Russell. He never did any autopsies like Dr. Sheridan. He never did any autopsies with anybody who was injured, was killed by a motor vehicle accident either, like Dr. Sheridan. He has no degrees in engineering, math, science, physics, biomechanics, but he did take a math class. So he did take some classes as part of the academy. The highest degree that he had was an associate's in administration for justice. And, that's who Trooper Paul is. So that's really in terms of the testimony, which experts are going against which. That's in terms of the testimony. So you got animal versus car, and you saw who supports the animal side along with your common sense. And then you also have the evidence of Trooper Paul on the other side of of who's going to say that it's a car. Now let's move on. But wait, you may be thinking as the jury, wait, hold on a second. Well, it's not just about the testimony, because there's also about the other evidence that you have to take into consideration. And that's true. You have to take into consideration all of the evidence in this case. Well, let's talk about the other evidence that could also point to the fact that this was a car accident as opposed to an animal accident. So we went through the experts, we went through the testimony, but now let's talk about the car. So there's a number of things here that I listed. Number one is that we know that John O'Keefe's hair was stuck on the bumper. Number two is his shoe was found on the curb. And we know that sometimes in pedestrian versus motor vehicle accidents, a pedestrian's shoe can come off, and it was found right on the curb, right where he allegedly was struck. There's also pieces of taillight which were found embedded in his clothing. We also know that Karen Reed left some nasty voice messages for John O'Keefe. She did not seem very happy with him. Also, we know that the people in the house that night testified that he didn't come in that house. And also, which could maybe even be the strongest piece of evidence, is that Karen Reed allegedly said, I hit him, I hit him, I hit him. So hold on a second. Maybe it's not as simple as I just made it, even though you're right. Your common sense is going to say that those are actually from an animal attack. But as I said, it's not like common sense cannot be overcome. It could be overcome if the case is proven strongly enough. And here we have the Commonwealth saying, okay, maybe Trooper Paul is not the greatest expert, but then we have all these other pieces of evidence. So I figured I'd make a little chart for you guys. Okay, so now I just put it together on a chart. This is something that you can perhaps do in the jury room. So on one side, you've got the animal, which is all the things that support that this was an animal attack. You got common sense. You've got Dr. Russell, you got Dr. Sheridan, you got Dr. Wolf, and you got Dr. Rentschler. And the other side, on the car side, you got Trooper Paul, you got the hair on the bumper, you got the taillight in the clothing, you got Karen Reed voice messages, you got the shoe found on the curb, and you've got the testimony from the people in the house. And you've also finally got Karen Reed's confession. I hit him, I hit him, I hit him, right? So now I would submit to you, ladies and gentlemen, without even analyzing anything, just looking at this problem that we have, you know what this is? This is a problem. If it's a problem, and there's not going to be a great way to solve this problem, you know what that equals? That means that there's reasonable doubt. Because on one side, you got the car, you got the evidence for the car. On the other side, you got all the evidence that says that this was an animal attack. Well, ladies and gentlemen, that is exactly what reasonable doubt is. You're not sure what to do. You got one side, bunch of evidence that it's an animal, and the other side, you got a bunch of evidence it's a car. If I were to stop my closing argument right here, your verdict would have to be not guilty. But you know what? Just for completeness sake, we're going to go through some of the arguments that this was a car. Okay, let's just go through this, because then I think you'll see, as we analyze this more and think about the evidence a little bit more, you're going to see that it's not really such a problem, even if we had to prove our case, which we don't have to prove our case. We don't have to say anything. The Commonwealth has to prove their case beyond a reasonable doubt. And just looking at this, right away you see reasonable doubt. But let's move on. Remember, Judge Cannoni said that you must consider Ms. Reed to be innocent unless the prosecution has proved beyond a reasonable doubt through evidence presented during the trial that Ms. Reed committed the crimes charged. So as we said, that itself, that chart alone, just left alone, equals reasonable doubt. But let's move on. Reasonable doubt, in my mind, is the following. If you have a reasonable explanation plus common sense. I think that if you have common sense, which we said, common sense that this was an animal attack, but even going into the side, the column, which was talking about why there's some evidence pointing to the fact that this was a car accident, there's also some common sense arguments that you can make with respect to those pieces of evidence. And you also have a reasonable explanation. If there's a reasonable explanation, well, then that also would equal reasonable doubt, right? So let's talk about Trooper Paul. Well, Trooper Paul, I think, is the easiest one to debunk because, quite simply, I think he's a good guy. He's trying to do his best, but he's just quite simply in over his head. He just can't compete with these experts. There's 4 other experts here. There's these biomechanical experts who are real experts, who have real degrees. The highest they got was not an associate's. I like Trooper Paul, but he's just in over his head. He can't compete with these people. So if I were to ask you, what would your common sense and life experience tell you when you have on one side Trooper Paul to believe, and you have the other 4 qualified experts, the ER physician, the medical examiner, you have Dr. Wolf and Dr. Rentschler? I mean, what would common sense and life experience tell you about that? Well, I think that's pretty simple. So I think very easily we can move on from Trooper Paul. So let's move on to the next part. What about those nasty voice messages? Is there any reasonable explanation for why Karen Reed left those nasty voice messages? Has anyone ever been in a long-term relationship before? Is everything always amazing and wonderful and you never get into any disagreements? Well, if you're that person, that's great, because you're probably 1 in a million. Most people in any relationship, especially if it's a long-term relationship, especially if there's children involved, things can get a little complicated. Things can get into a dispute sometimes. You can have disagreements, and you know what? You can say things that you really, really should never have said. And especially if you've been drinking, that can definitely doesn't help the situation as well. So remember when those voicemails were left. It's left after a long night. There's definitely drinking going on, no question about it. And they had some issues, during the of course, there was. It seems like they got along throughout the night, but maybe something sparked her anger, something to spark the disagreement that they had before, and she left some terrible messages. Now, also, we know that there's no history. There's been no evidence of any sort of history of domestic violence in this case. Now, just to take a little pause, let's asterisk here. Again, most of the time, domestic violence issues are dealt with in pretrial stuff, whether certain things are allowed to come in or not. So we can kind of skip over this, but a lot of times they bring in domestic violence to show, not character evidence, but motive, opportunity, and intent. So, it's a question whether you can actually argue this in closing argument. I'm just throwing it in there because maybe it's something that you could. I'd have to see with the judge. We'd have to see how pretrial was going on. But anyway, I'm throwing it in there. Next. What would your common sense and life experience tell you about this disagreement? What about those nasty voice messages? She really didn't like John O'Keefe, right? At that point, she was very upset at him. So there's, I think, 2 explanations. Either she's mad, right? Sometimes people in relationships get mad. They have a disagreement, and she's saying things. And when she's definitely drank a few drinks and she's letting things out, it's 12 o'clock at night. She was waiting for her John to come out of the house. She's very upset. So she's mad. That's one option. The other option is that she turned into a NASCAR driver overnight and decided to murder him by gunning her engine in reverse. And then, after deciding to kill him, is dumb enough to leave messages on his voicemail about how mad she is at him. So these are the 2 options you can choose. Now, is it reasonable? Again, it's just a reasonable doubt. So is it reasonable that she was actually just mad at him? Is it reasonable that, unfortunately, sometimes in relationships you hear couples talking to each other like that, and sometimes they just make up afterwards and everything's great, and maybe they need to get some counseling or something else, but does that turn the person into a cold-blooded murderer? So I think that there's definitely your common sense, and there's definitely a reasonable explanation here. So that would definitely take care of the issue of the nasty voice messages. All right, let's move on. What about I hit him? I mean, that's just a confession. I mean, doesn't that really, you're right that common sense, just looking at the picture, would tell you that this was an animal attack. But the fact that she actually acknowledged that she hit him, I mean, that really takes the wins out of that argument. And maybe you have to get away from common sense. Well, let's just, for one, assume that she actually said that, which, again, if you're the defense in this case, you're not going to concede on that so easily. But let's just assume, for argument's sake, that she actually said those words. Now, we do know from the evidence at first, when she was also completely hysterical and frantic, she was asking, did I hit him? Could I have hit him? Maybe I hit him. And she was absolutely frantic. And everyone testified that she was frantic that morning. So what would common sense and life experiences tell you about the fact that she was screaming in a frantic state that morning that she hit him? I hit him. Either one option is that she actually did murder him on purpose, 2nd-degree murder, guilty. She murdered him with intent, and then decided the next morning to confess to Jennifer McCabe. Maybe that's one option. Number 2 is that she was frantic. She was drinking and driving the night before, and she thinks in her state that she was the last one to be with her boyfriend, and her boyfriend ended up dead, and now she's blaming herself, not knowing what really happened. Is that a reasonable explanation? Is that not reasonable that you have someone who the night before drank and was driving? Last thing that she was with her boyfriend, and now the next morning she's absolutely completely frantic, which everyone has testified to, and that she's hysterical, she's screaming on the phone, and then she just decides, I must have done it. I must have hit him. Was that really a confession, or is this just somebody in a completely frantic and hysterical state? Well, again, if you're not 100% sure, well, then there's definitely a reasonable doubt about what she was actually doing. It's definitely a reasonable explanation. So again, I think with reason and common sense, you would also have to agree that this fact that she said, I hit him, is not conclusive that John O'Keefe was actually hit by this car. All right, let's move on. What about the shoe that was found on the curb? Now here, the issue is that the question is really a question of physics. At what rate does a person have to get hit, and what angle, and how much, at what point of the center of his mass, and things like that. So here, I think it's a little bit tricky to ask you to use your common sense with a shoe found on the curb. I think you actually need some expertise, which is why we did have some experts talk about this specific issue. Now remember, this comes back to the experts again. So that goes really back to the first slide, which talked about Trooper Paul versus Dr. Rensler and Dr. Wolf. Now, Dr. Rensler, Dr. Wolf, which again, their opinion was that if it's a side swipe, yes, they did acknowledge that if this was head on, that there are times when a pedestrian's shoe could come off in a car crash, but they said that in a side swipe, you would not expect to see the shoe come off. And Trooper Paul, as you know, the closest that he can argue is that that's what it came off, that his shoe did come off when he was doing a spin around and landing 10 feet away from the car, that his shoe came off as well. That was, again, Trooper Paul, again, versus Dr. Rensler and Dr. Wolf, using all of their degrees in biomechanics and engineering. And then you're going to have to use your common sense, again, to whether you're going to believe Dr. Rensler, Dr. Wolf, or Trooper Paul. But let's say you don't know who to believe. Maybe you really have a legitimate question about who to believe, Trooper Paul, even if maybe you just you're not impressed by degrees. And therefore, if you just look at the evidence, if you look at who actually said that the shoe came off because he was hit by a car, who actually said that in trial? The closest that you can get to that is Trooper Paul. I'm not sure if he said this straight out either, but the closest that you can argue is that Trooper Paul. And again, now you're left with Trooper Paul versus Dr. Rensler, Dr. Wolf. Now, I would submit to you that obviously these other Dr. Rensler, Dr. Wolf are far more qualified and are far more believable. But even if you're not sure, you know what that equals? That equals reasonable doubt. So again, you're left with reasonable doubt about this specific issue as well. Let's move on. What about the hair on the bumper? Well, again, we have to think about what the Commonwealth's theory of the case is. Their theory about this hair on the bumper is the fact that he was sideswiped. So they never argued that he was hit in the head. He wasn't hit in the head by this car. They've never argued that. They argued that he was hit in his arm. That's what Trooper Paul said. Wasn't hit in his head. Now, if he was hit by a side swipe, so then how did that hair come off of his head and land on the bumper? You got to ask yourself that question. Well, the only explanation, again, this is using the Commonwealth theory, is that during that side swipe in this blizzard, a hair came off of his head and flew onto the bumper, right, on the taillight. Well, what about any other time that night? He was near that car every time that night. They were out together in Karen Reed's Lexus. So he was out and about in and around that vehicle the entire night. Is it possible, is it reasonable that maybe one piece of hair on his head flew off and went to that bumper the same way it would have if he got sideswiped? Is that not a reasonable explanation? Is that not a common sense explanation? Well, I think, again, if you would argue to me that the only way that this would happen is if his head actually got smashed by the car, which, again, Dr. Rensler completely obliterated, and so did Dr. Wolf. But that wasn't even the Commonwealth's theory. The Commonwealth's theory is that you got sideswiped just on the arm. So if that's their suggestion, and the hair just flew off his head because you're in the middle of a blizzard, well, the hair can flow off your head also just by him scratching his head near the car. He's in and around that car the entire night. And don't forget that is his girlfriend. So they're around each other a lot. He's probably around her car a lot. So if that hair can stay on that bumper through a blizzard, that night and through being towed everywhere it went, well, who knows how long it was actually on that bumper for. So a lot of, again, reasonable doubt when it comes to that hair on the bumper. Well, let's move on. What about the testimony from the people in the house? They all said that he didn't come in. Now, number one, remember that basement was as soon as he came in. So who knows if actually everyone in the house, maybe they're actually saying the truth. And as soon as he came in, only 2 people actually had to lie. And then that's who brought him to the basement and nobody else knew about it. That's number one. But number two, let's think about this testimony from these people. These people said that they did not see John O'Keefe enter the house. You know what else they didn't see? They also didn't see him lying in the grass, this 6'2" person, 220 pounds, 240 pounds, whatever he was. And they didn't see him lying in the front yard when they left also. So, I mean, how good is their eyesight and memory about that night? And they don't remember him coming in. They don't remember him in the front yard when they were all leaving the house. I mean, that's hard to believe. These are the people that you're going to trust to overcome the common sense, overcome all the experts. And these are people that did not see this man 6'2" lying in the house, lying in the yard. These are the same people that deleted phone calls, destroyed their phones. And again, even if we were to believe them that John O'Keefe did not enter the house, that doesn't prove to me that he was hit by a car. That just shows that he did not come into the house. That's all that shows. So again, it's not really directing you to come to the conclusion that he has been hit by a car. So let's move on. What about the taillight in his clothing? Okay, so let's think about the taillight, and these were microscopic pieces that were in his clothing. So remember, there's 47 pieces of taillight that were flying around that scene that night. Now, 47 pieces of taillight, allegedly that was falling around, fledging. It's all over the scene that night. And John O'Keefe is somewhere around there also, lying around the same area where these 47 pieces of taillight are, right? That's the Commonwealth theory here. And it's not reasonable that a little piece of that taillight would get into his clothing while he's lying there. Everyone agrees that he was lying there. Everyone agrees that he was found there. And around that same area, there's taillights. And also, don't forget that those 47 pieces of taillight were in evidence for 3 months. Maybe it's not 3 months. I may have got the time off, or maybe 6 weeks. But it was in the till March 14th, until it was actually sent to the labs. And there's not really some such clear logs about what was going on with those pieces of taillight and the clothing. Were they mixed up? Were they put in the same bags? Were they bagged together, then bagged separately? Not such great logs about what was going on with those pieces of taillight also. Oh, and don't forget, remember the person who was in charge of those items? That was a fellow named Michael Proctor. Remember those text messages he was talking about, how his integrity and his quality of investigation, how he's talking about Karen Reed about this case? So let's not, again, this is the integrity of the officer who we have to trust with all this information. Again, these are reasonable explanations. We're not making up that Michael Proctor sent those text messages. That was straight in evidence. So this is the person who, again, you have to trust to overcome your common sense, overcome all the experts who say that it was not a car accident. It's going to be difficult to do. So that is the question. So is this still a problem? Is it still a problem? Doesn't look like it. We just took care of all really the issues with the car. So definitely, it's really looking like not only we didn't have to do any of this. None of this we had to do. This is what Judge Cannoni said. Ms. Reed does not have to do anything to convince you that she is innocent. She does not have to explain anything. So it could have looked like this. We could have left it exactly like we did 10, 15 minutes ago, where you've got, even if we were to imagine that some of these arguments on the side of the car are actually decent arguments, but you still have all of the evidence on the other side. And Karen Reed doesn't even have to disprove all the other theories. Even if we just left like this, again, it would result in an acquittal. So, ladies and gentlemen, if you just use your common sense in this case, and you run through the steps, and then you put it through the evidence, it all becomes very clear what your verdict to be. So this, like I said, is very simple task of use. All you have to do is you go back to the jury room, you think about common sense, you run the evidence through the common sense, you think about all the experts that were put on this case, and it's very simple what your conclusion has to be. All right, well, that is kind of the idea, how I would use just this area of common sense to be an argument. Look, we're still under 30 minutes, so we'd still have another 30 minutes to argue maybe the coincidences part of the closing argument, which I did in the other video. Maybe we'd be able to do other things. But anyway, that was just kind of an idea of what I had, how to show that if you just use your common sense, then you would side on our side. Now, again, This is just me stepping into the defense attorney's shoes. If you guys want me to step into the prosecutor's shoes and do that in another video, maybe we can do that. We still have some little bit of time off. Maybe we can squeeze that in. Otherwise, then that will be it for now. Thank you all for watching. If you haven't yet, please subscribe, like, and we will see you next time.